Köszönöm, hogy meghívták a konferenciára. Thanks a lot. It is a pleasure for me to be here. It's all I have myself at home in Hungary because our historical connection and myself really very good here. Thanks a lot. I was asked to say something about sovereignty. I'm a practitioner in law, so for me it's not the best area of interest, but I will focus on the selected issues I think they are most interested in. Sovereignty is a concept of fundamental importance for the theory of international law. The notion of sovereignty is a legal concept that defines a certain state's affairs. From the cognitive perspective, it refers to factual sphere and not a legal one. Only by accepting the principle of the state sovereignty can the fiction of equality of states in the light of international law be maintained. In reality, contemporary international law is based on the presumption that all states that declare such state affairs are sovereign or sovereignty equal, irrespective of actual political inequalities between them. In contemporary political science, the concept of sovereignty is sometimes used to include other actors of international relations, and it may even be extended to individuals. In classical international law, it is exclusively an attribute of states. The state is the basic and central concept and subject of international law. The theoretical concept of shared sovereignty actually contradicts the essence of national states. Instead, they provide a natural basis for the theory of global government, which is contrary to international law theory. State sovereignty is a particularly crucial issue for the countries of Central and European Union. In our region, the perception of sovereignty as well as the early recognition of treaties to independence is much more pertinent than in other regions of the old continent. We have exceptionally unfavorable geographic location, especially Poland. We historically been particularly exposed to the actual violation of our independent existence. It is worth to mention about significant threats posed by totalitarian left-wing ideologies, National Socialism and Communism, by the way, adopted by countries with tradition of political domination in the region. Bearing in mind the socialist experiment of the past and the present collapse of values of the European order is to be based, we approach the idea of federalization of European Union with some extreme caution. It's worth devoting some attention to borderline problems of sovereignty. I will shortly focus on contemporary definitions of state sovereignty in international law because it denotes a lack of dependence on the power of other entities. This position should be recognizable from the external as well from the internal perspective of the state. From the constitutional viewpoint, the concept of sovereignty is often replaced by the essentially identical concept of independence. Although the latter is associated with politics rather with the law. Sovereignty is generally described in terms of behavior characterized by independence. For example, in the Constitution of the Republic of Poland, the notion of sovereignty and independence are used interchangeably. According to the classical formula, sovereignty is associated with the state's exclusive power over its own territory and its own citizens, including the internal freedom of shaping economic relations. It also refers to the external activity of the states, entering into alliances, establishing diplomatic relations, creating external economic ties, etc. The internal and external sovereignty of the states is clearly distinguished in the doctrine. It is precisely defined in the old Polish legal doctrine as całowładność. It means the competence to regulate all domestic affairs, and the later as samowładność. It means legal independence from external factors. On the ground of sovereignty are built derived normative constructs provided for international law. Their character may be positive. They are legal institutions that directly support state sovereignty. It is, for example, the principle of sovereign equality, the right of self-determination, or they create prohibition against behaviors and entities of international law that violate sovereignty. For example, the prohibition to intervene in the internal affairs of states, prohibition to use force in international relations, etc. Sovereign equality of states is presented in the United Nations Charter as fundamental principle of the legal order. It ought to be mentioned that the concept of sovereign equality is also influenced treaty law and customary legal rules connected with diplomatic relations and practice. Sovereign equality means legal equality. It's not synonymous with the political equality of subjects, which may sometimes result in special rights connected with the international status. This is the status, for example, of great powers of United Nations. Generally, the equality of subjects has a formal character, which does not affect the exercise of the law as it depends on factual factors, for example, the access to the sea. In contemporary international law, the concept of part sovereign states used in the history of international law does not exist anymore. These entities were characterized by lack of independence in external relation. Partial sovereignty of protectorate denoted a lack of sovereignty. An autonomy of dependent area, even if it reflects of its former sovereignty, results from the consent of the sovereign states. The relationship between the protector and the protectorate state is termed suzerainty. In Poland history, we had some examples of these entities. The Free City of Cracow was a protectorate between 1815 and 1846. In the interwar period, we had a situation of Free City of Danzig, which was a protectorate over the protection of Poland, and the supervisor of the protection was League of Nations. But the position of these dependent states or protectorate results from special legal status imposed of the given entity, not its free will. The matter of this territorial entity are subject to the authority of the protector. Such a situation should be clearly distinguished from the conferral of analogous scopes of competences by one sovereign state to another. I will mention about it later. The trait of losing sovereignty does not seem to be particularly real nowadays. This is due to existing de jure legal mechanisms supporting the maintenance of sovereignty by states. In view of unlawfulness of war or aggression, even a complete annexation of the territory is not de jure regarded as a loss of statehood. Therefore, there is loss of territory and real power of the population does not simply lead to a loss of sovereignty. The history of Central Europe knows examples of governments functioning in exile. We have many examples in the Second World War, especially Poland, Czechoslovakia. We had a government in exile in Paris and after in London and the same Czechoslovak Republic. Regardless of this, any treat of territorial annexation, whether explicit as in case of Crimea in 2014, or de facto throughout the unrecognized external subject, as we have seen in Donbas region, it raises fundamental question about the loss of sovereignty over the territory. The loss of the actual possibility of exercising sovereign rights over the territory undoubtedly undermines the sovereign functioning of the state. The passage of time, however, is also an important factor. It may lead to the recognition of illegal situation as legal by the increasing number of countries. It's worth to mention, however, that states are free to relinquish their sovereignty. This happens by transferring the sovereignty from one state to another as a result, for example, of unification. History knows many examples of federal states whose constituent part used the sovereign entities. As a result of unification, the sovereignty expired. It was conferred on the one united state. Another important question is economic sovereignty. Liberalized or free trade is not perceived nowadays as a threat to sovereignty. Different opinions in these regards were formulated in the interwar period. In 1951, the Permanent Court of International Justice recognized the customs union between Germany and Austria as undermining the latter's independence. But following the Second World War, however, the increasing number of free trade agreements, customs union, and the conclusion of general agreement on tariffs and trade changed the perception of economic threats to state sovereignty. Economic ties were only rarely perceived as a threat to sovereignty. However, much still depends on the nature of this relationship. Corporation today often has a budget they are many times greater than that of the country. It allows them to influence the political decision of states. On the other hand, capital does have nationality, which is well understood, especially by the most powerful and largest country in the world. Trade in raw materials show that resources such as crude oil and natural gas can be an effective economic weapon used, for example, by Russia against Central Eastern Europe. Countries such as Poland, for example, had bad experience of being blackmailed by Russia in connection with the supply of oil or gas. Maintaining independence in this respect requires costly products connected with the diversification of suppliers of the raw materials. It has actually happened in the case of Poland, following the launch of a gas terminal and the construction of pipe gas line from Norway. Dependence on uncommunicable suppliers, Russia certainly poses threat to stability of economic development. In such circumstances, implementing economic policies is a real challenge for the state authorities. A fundamental question arises at the point, does the economy of such sanction against Polish fruits and meat or agricultural products. We tried to make something, and in fact we couldn't take any retaliatory measure because we have taken at this time only gas from Russia. So the retaliation would be disaster for our economy, in fact. It will be suicide economy. Activities characterized by economic blackmail, so-called soft coercion, cannot be considered coercive, carrying the consequences of Article 52 of Vienna Convention law and treaties. Nevertheless, this is a form of influence on a state. It may deprive of real, if not theoretical, freedom of action. But in theory, it may be difficult to demonstrate the violation of sovereignty as a result of the fact of forced dependence of a supplier of raw materials. The science of law must distinguish between the non-legal pressures resulting from the clash of state interest, economic interest, from violation of sovereignty due to the breaching of fundamental norms of international system. The main problem is whether the sovereignty may be limited. Can we define limitation of sovereignty, transfer of sovereignty, or transfer of competences? Based on relevant agreements, states may apply solution, delegate the temporary exercise of rights identified with sovereignty over territory of another's entirety. However, this does not imply a loss of sovereignty over the territory or a restriction of the transfer of sovereignty. In this case, the distinction between sovereignty over territory and territorial rights exercised as a result of contractual title between states resembles the relationship of ownership and possession in civil private law. Sovereignty is the full title to rule a territory as understood by public international law, but the sovereign entity may relinquish some of the symptoms in favor of another entity. However, this is a transfer of competences, not transfer of sovereignty. The notion of the transfer of sovereignty itself is alien to classical public international law. In the same way, various types of territorial lease mechanisms can be developed concerning, for example, military bases, which resemble the transfer of possession of things in civil law, or servitude, in a case the right of passage through a territory, for example. The latter is perceived particularly negatively in Central Europe. For example, the demand for rights of a corridor from Germany to Eastern Prussia throughout Polish Gdańsk Pomerania in 1939 was the reason of Second World War. Now we have a similar situation in Poland because there's a gap between Poland and Lithuania, Suwalki gap, and it's the shortest way from Belarus to Kaliningrad region. It's really the same situation in history. The history of Central Europe is particularly telling case connected with authority exercised over a territory by an entity other than the sovereign. It's concerned the Bosnia and Herzegovina case till 98, after it started to be part of Austria-Hungary, but before it was Ottoman Empire, under the Austrian autonomy, under the Austrian administration. In practice, many such cases in other geographic areas are known to international law, like Panama Channel, like Hong Kong lease, Guantanamo, and so forth. In practice, titles that introduce limited administrative powers of one state over a part of another state's territory also apply to much smaller functional territories, such as ports, port case, or military bases. Depending on the content of the agreement between states, the exercise of limited territorial authority might entail the establishment or exclusive or partial jurisdiction of a state exercising administrative control over the territory. Delegation of competences by some states, including in particular the so-called microstates or mini-states, is a very natural tendency. Due to objective factors, demographic situation, economic situation, such microstates are unable to undertake costly diplomatic activities or to maintain real relations in most countries of the world. Case on conferring competences on other entities are not uncommon. Of course, there is only a conferral of competences, not on sovereignty. The confer has the right to revoke the transfer of powers in all or in part at any time in order to exercise them by itself or transfer them to another entity, which may be another sovereign state or non-sovereign international organization. Cases of such revocation of competences are also not uncommon in international law. A good example is the situation of Fürstentum Liechtenstein, which used to distribute and withdraw the competences between first Austria, after Switzerland, after European Free Trade Association, and on the end European Economic Area. And now we reached the main point of this problem, transfer competences to the international organization. It's the most common situation today. States conclude an international agreement with each other in which they create a new entity, an international organization. It is particularly important in practice in the case of the so-called supranational organization. They are usually tasked with achieving economic or even political integration of the member states within the scope of powers conferred upon them. Such secondary entities have self-reliance, and that's essential for the purpose. They act on their own behalf and on the interest of the organization as a whole. They issue binding legal acts of secondary law on the basis of which a separate legal order is built, this sui generis order. In addition, the assessment of compliance with the secondary law by a member state is subject to a judicial authority established with the organization. Due to these factors, we can notice their exceptional character. The strong impression that this organization managed the affairs of its member states. As a result, it contributes to the propagation of theories about sovereignty of the international organization, which is false in fact. Regardless of the nature of international organization, it is a secondary subject of international law. It can be dissolved by the member states, which can eliminate the legal order created by this organization. States can also withdraw from this organization individually, like, for example, Great Britain from United Union, European Union. Since its legal existence fully depends on the will of other legal entities. It is a fundamental mistake to speak about sovereignty in any respects of international organizations. In the light of contemporary international law, a sovereign entity cannot be liquidated at the will of other entities. The ultimate impossibility of management of its own existence certainly makes such an entity as a supranational organization non-sovereign. If you are not lord of your own life, you cannot be sovereign. While transferring competences, only the sovereign state is active. An international organization merely absorbs its competences from states. It is like the recipients in the case of donation agreement in civil law. The scope of donation is always determined by the donor. International organization may not actively request a conferral of competences or lawfully extend the scope of competences to an area not covered by the original confer. It's fully confirmed, for example, in the Treaty for European Union, Article 5. The limits of union competence are governed by the principle of conferral. In theory, possibilities for European Union to act in areas which do not fall within the exclusive competence is very weak, but in theory. In practice, however, problem is the violation of the competences of EU treaties by EU bodies. The fact of conferring competences clearly confirms the sovereignty of the conferrer. The entity receiving the competences does not have to be sovereign, and in the case of international organization, is not sovereign. The interpretation of the scope of the confer of competences is subject only to the assessment of the conferring states. In particular, it is unacceptable to make self-findings and unilateral agreements concerning the arrangements concerning the scope of the conferral by entities upon which the competences were conferred. It is worth quoting at this point the ruling of German Constitutional Court in 2009 referring the transfer of powers by a state to the European Union. The concept of states as masters of the treaty, the Herren der Verträge, cited by the court accurately reflects the essence of the matter. It's worth noting the conferral, the competence of international organizations also stipulated to a limited extent by constitutions of some member states of the European Union. Undoubtedly, it's up to them to make the final assessment of action undertaken under this treaty. It is worth noting that, for example, the Article 90 of Constitution of the Republic of Poland provides for that the Republic of Poland may, by virtue of international agreements, delegate to international organization the competence of organs of state's authority in relation to certain matters. This provision mentions the delegation of competences and not of sovereignty, only in certain matters, therefore to a limited extent, only to a limited extent, in fact. At the end, one should notice the threats resulting from the change of the perception of sovereignty. As we mentioned, political concepts indicate the distribution of sovereignty to other entities. They're based on categorical shift. It's a fundamental logical fallacy that assumes the identity of the concept of sovereignty and the state competence. Sovereignty is not just unlimited power. It is not the sum of powers in the hands of the sovereign. However, the sovereignty may be associated with the rights of the state to distribute its powers. States are free to choose how to perform their functions. The most dangerous theory that threatens the sovereignty of the states is the theory of global law. Sovereignty, as understood by Hans Kelsen, was to be limited as the result of institutionalization of international cooperation by establishing global international organization. The law on individual countries would therefore need to be gradually subordinated to global law, which would be systematically developed on the basis of the activities of this organization. It means the transfer of competences, ultimately resulting in the assumption of sovereignty or the creation of some unrealistic form of global governments, which is contrary to natural law. It is essentially a violation of sovereign rights without any title and legal legitimacy. Unfortunately, this issue is not purely theoretical. The creation of such a superstate power could take place only with the express consent of states, indicating the need for such de jure unification. On the other hand, it's worth bearing in mind that development of world orders in modern history did on several occasions involve the abandonment of the existing principles and the adoption of new, completely different one, which in the light of the existing order would be considered illegitimate. It happened after Napoleon War, it happened after World War, it happened after the Second World War, maybe it will happen soon after Third World War, maybe not. It would be very interesting theory if it wouldn't be realized by European Union in practice. We can observe the activities of organs of international organization that consist issuing act of secondary law concerning matters beyond their competences and of judicial authorities issuing decision outside their jurisdiction. A state whose sovereignty has been violated as a result of such practice has the right not to recognize the effects of the organization's legislative activities and not execute the judgment of its judicial bodies. The organs of European integration seems to be departing from the regulation contained in their own treaties. In Europe, there is a now dispute over competences. Mr. Professor has told about it. There is a dialogue between the courts, but in fact it's a little bit like a war. It has led to the emergence of phenomena that are far removed from the principles of democracy. Bodies of international organization without any democratic legitimacy and theoretically operating only within the scope of powers conferred upon them by states, are appropriating the competence of primary entities on the basis of decision of international judiciary bodies. The practically unlimited jurisprudence of international judicial bodies leads to a new system, it's judicracy in Europe. By the way, members of European courts are elected by secret ballot from among people who are dependent on political parties and groups of influence. The court of an international organization usurps the right to contradict the decision of government of sovereign and democratic states. Such practice of the Court of Justice of the European Union or the European Court of Human Rights in relation to first Hungary, after Poland, and now to Romania are a clear example of this phenomenon. Opposition to such clear and lawful practice in proof that the countries of the region continue to be sovereign Indeed, throughout such ultra-virus action, international judicial authorities risk issuing sentences existent judgments, entering into a significant dispute with constitutional courts and authorities of the member states. Now we have a specific war between the national tribunals and the European Union, with clear support from the European Court of Human Rights, which is visible in the case of Poland, constitutional conflict. It concerned the domestic judiciary, and this matter, clearly reserved for the competence of the member states, is subject to appropriation by the Court of Justice of the European Union. What is very funny, the European Union, the Court of Justice of the European Union situates itself as a main and true defender of the communist judiciary, because our judicial system hasn't been changed since 1945. The first change, the real changes, was in 2015, and after started this war with the European Union. It does mean that Lenin is always alive in the European Union. Okay, thank you very much. Sorry for my Slavic accent. For me, it would be better to speak German. Just my daughter told me, speak German, don't speak English because you have Slavic accent. Sorry for the time I have. I think elnézést bemutató idejének tülepésért. I know, I've spoken good. Thanks a lot.